Everybody, it's Dave Stouse. I am, for those who haven't been on a prior webinar, I'm the practice group leader at Husch Blackwell's Privacy and Cybersecurity Practice Group. I'd like to welcome you to today's program. We're going to talk to you about U.S. state privacy law developments. At the beginning, they always ask me to talk about just a few housekeeping items. I'll talk about two of them. One is questions. Feel free to ask whatever questions that you have. You can throw your questions in the chat box. We have a ton of content today, so I don't know that we will get to the questions. But I think I've said this in prior webinars, like we do our best to answer questions if we feel like we haven't answered them throughout the course of the conversation today. I'll shoot you an email. I think people have gotten emails from me at all times at random times of night and weekend and stuff like that, answering questions. So don't be bashful. Feel free to ask questions. We just might have to get to them. 2 CLE credits. I understand the CLE credits are available. That's the extent of my knowledge on the CLE stuff. I think there's a button you can press or something like that. Okay, enough of that. So this is our crew today. You've got me on the right side. I looked like pre-COVID. I have a beard now. And we have TK. TK, you want to say hello?
Yeah, hello everybody. We're so excited for you to be joining us today.
Yeah, so before I change this slide, the QR codes there will take you to our LinkedIn profile. So I always tell people, hey, if you're interested in this subject, follow us. We're obviously pushing out a lot of content on a regular basis on this. For those who do not know TK, and I did a horrible job of introducing her properly, TK is with the IAPP right now. She's in the Western Research Fellow position. And TK's job, or part of your job, is to maintain the state privacy law tracker, right?
Yep.
So you are the perfect person to be giving this webinar. Great, okay. So I think if you've been on a webinar before with us, I always like to start off with a roadmap. This tells you where we're going. Hopefully you can kind of anticipate it. You're looking at this, you're probably thinking, my God, how are we ever going to get through 13 topics? I don't know. I don't know how we're going to get through 13, but we're going to do our best. I said before, we just have a ton of content now. There's a lot of states. So we're going to go quickly. 11 and 12 there, I did want to point those out, the BCDPA amendments and the California update. I'm hoping we get there. If not, check out the blog. We've got a lot of updates on those. But it just felt like I was doing you a disservice if we didn't at least talk about those issues or try to talk about those issues, because they are part of this whole discussion right now on state privacy law, right? Okay, so the way we structure this, we'll have some overview slides first to give you the general lay of the land, and then we will talk about individual states, and you've got them listed there. I don't have to repeat them. So there's 9 states we've picked, and we've picked ones where we've seen movement or because they are unique. Now, I can't emphasize enough, and this is going to come up repeatedly, right? Everything is subject to change. This is a snapshot. Things were changing last night in Florida. Things were changing this morning in Utah. It's just a moving target. I know you guys get that, but we're going to give you a snapshot. If you're listening to, I don't know what the shelf life on this webinar is, like an hour or something like that, right, given how much things are changing. So we picked these states. We'll talk about them. We'll weave in updates from other states. Even when we were just coming on the webinar, we were grabbing more information. And then, at the end there, that appendix, right, what we did was, even though we're not going to talk about every state, every bill, we provided an appendix that does things like Glba exemptions, Hipaa exemptions, status, applicability, enforcement effective date. And we did that for probably like 80–85% of the bills that are out there right now. There's some states like North Carolina and South Carolina we excluded because there just hasn't been any movement in 2 years on those bills. And then ones like Maryland, we didn't put in there because the last committee hearing they talked about revising the bill entirely and maybe moving to a BCPA model. So, some editorialism went into, that doesn't make any sense, editorialism. Some selection process went into picking which bills, but we were trying to provide you guys with as much content as humanly possible here. Okay, that is the roadmap. We will now go over to the overview slide, and TK will talk about jurisdictions so far.
Yeah, so as Dave mentioned, our main focus today is going to be on the more active bills we're seeing, but we did want to provide just a basic overview up front to show you what's out there. But we're not going to spend any time on bills that have died, like Mississippi's. And since it looks like Washington's cutoff date for considering bills in their House of Origin was last week, we won't be discussing those 4 bills either. But the bills in states like Alaska, Florida, Indiana, those that Dave just mentioned, they'll get some airtime, obviously. Also want to note that we added in Connecticut here because we know a bill is on the way. It just hasn't been introduced yet. And before we move on, another thing to keep in mind is that Indiana and Florida sessions, they're going to be closing here shortly, so we should know one way or another in the next 3 weeks with those states.
Yeah, and just to add on to what TK was saying, so Minnesota's coming. We just reached out to Elkins and said, hey, do you have an update that you want us to share? He's looking at getting that bill out shortly and having a March hearing. So, expect Minnesota to come in the near term. I don't think the immediate near term, but, soon to be coming. Utah's having a hearing right now, and this bill just came out of, I don't say nowhere. We knew Cullimore was thinking about it. And then Washington, TK mentioned that the bills had skipped the deadline. Understand one or two of them might be characterized as an ITB bill, necessary to implement the budget bill. So we're tracking those. It just doesn't seem like there's a lot of momentum, which is why we've kind of decided not to address them. And then last thing I'll note is, yes, District of Columbia is up there, but that's why we call this 2022 jurisdictions so far, not states. I don't want to get into a debate over statehood. Okay, the privacy tracker.
So the IPP started its state privacy tracker, I think, back in 2018, and this is the map version that covers the current status of state legislation, as well as any action from the prior years. So while this graphic provides a quick snapshot of where states are or have been in the process, our chart version of the tracker, which can be accessed through the QR code there, because it's way too big to fit onto a slide, it goes more in depth by actually listing out all the bills and showing which consumer rights and business obligations are included in each.
Yeah, and just to give you a couple more resources before we get started, I think a lot of you know we have at Husch, we have the State Privacy Law Tracker. You can get to it through the QR code there. And you just have to, it gives you all the bills, right? So, for example, Iowa just changed their bill number. We just updated it. So we're trying to keep track, and it basically lets you link to all the bills, so you can get access to them yourself. And then the color coding there, Shelby Dolan came up with our color coding this year, which I think looks great, but give credit where credit's due. And then another thing, too, I think you guys are familiar with this one. A lot of you are, but we do, at Husch, we do weekly updates on the status of the state privacy laws. We wait until the weekend, and we do them then because it's basically like the only time that you can actually get a little bit of calm in the state privacy lawmaking. And so we push out our updates on Monday morning, and LinkedIn, I typically push that out on Sunday. So anyway, if you're interested in this, I encourage you to subscribe to the blog or follow on LinkedIn, those types of things. Okay, so first bill then that we want to talk about is Indiana. And moving right along, at each of these states that we're looking at, we're going to have a slide that looks like this. This is sort of like our give you the bill in a snapshot type of a slide. And so, here the status, we obviously had it pass the Senate. It did pass out of committee in the House. It's waiting a second reading now on the House floor. Not on today's calendar, so wait and see. Understand that there is a February 28th deadline for reading of the Senate bills in the House, and we'll see. I mean, sometimes deadlines seem to be optional in state lawmaking. But
discretionary.
Yeah, right. It's all very strange. I mean, there is a certain amount of fool's errand trying to follow all of these state lawmakers and legislation. But, point being is it's moving, it's past one chamber. Really, in the last committee hearing, the hang-up, at least, on the testimony, is the AG's office was concerned about being able to enforce the bill without the funds necessary to enforce the bill. So that came up in the last committee hearing. And it has been the case where, AG enforcement has been a big deal to date on getting bills passed. Certainly was a huge deal here in Colorado with passing the Colorado Privacy Act. Also, too, it looks like the VCDPA now, keep in mind this bill when it was originally introduced was more akin to CCPA, and it did a switcheroo on before the first hearing, and now it's the VCDPA. So a lot of this stuff, like applicability enforcement, it is very much, if you know Virginia, you're going to know Indiana, and I'll tease out some of the differences, but that's really what it comes down to. Really want to point out the effective date. If it passes, 2025, not a typo, right? It's 2025. You had time to figure it out. Now, I think that works in, though, with understanding that Virginia is going through a process right now of amending its bill, right? And we've talked a lot about that on LinkedIn and on the blog, and we'll hopefully touch on that briefly at the end. But if it's 2025, if it passes and it's 2025 for the effective date, then you're talking about time to bake in any types of changes to get interoperability there. Okay. Exemptions, listen, it looks a lot like Virginia. No surprise because it is based on Virginia. Wanted to point out nonprofits are exempt here. That is not the case in Colorado, but it is the case here. Right. Okay, so this is where it's very similar to Virginia, but if it passes, right, and if you start hearing things like, well, it's not as strong as Virginia, right, this is probably what people are going to be pointing to. So the first one there, the access personal data, right, you're familiar with that one, this concept of you can access your personal data. There is an alternative in the Indiana bill that does not exist in other bills, which is the business can decide in lieu of providing you your data, they can provide you a representative summary of the consumer's personal data that the consumer previously provided to the controller, right? So the business has a choice of basically, hey, here's your data, or here's like a representative summary, right? Obviously, a business-friendly change there. And it's also, words are significant in these bills, right? And it's also, it says, it's the personal data the consumer previously provided to the controller, right? That's not everything the controller collected. That's what the consumer provided to the controller. It's a big difference, right? If you're buying lists, if you're LexisNexis and you're collecting information from multiple sources but not directly from the consumer, it's a big distinction, right? And you see that too, not only in the access personal data section, but you also see that language in the correct inaccuracies section, right? That would be correct inaccuracies on data that the consumer has provided to the controller, not all data that the controller has, okay? All right, I mentioned before VCDPA amendments, that could factor in here as well. There's an amendment being considered right now in Virginia on the right to deletion, and that would add a new exemption there. It's not part of this bill right here in Indiana, but it's something that, if it passed, and that's a big if, that, you could potentially see it get added in. All right, other provisions, listen, you recognize these, right? I basically could be giving Virginia crash course right now. Same thing, sensitive data, privacy policies, et cetera, et cetera. What I wanted to tease out here is a couple of things. One is sensitive data, that may change in Virginia. Virginia is considering a bill right now to change sensitive data. That's not baked in as of today into Indiana, nor is it, have I seen it baked in. I think maybe Wisconsin has it baked in. I think they're yesterday's hearing. But, these are changes, even in the same structures, even when they're taking, the same bill from Virginia and they're using it, there are divergences here. And there are significant differences in sensitive data treatment between Colorado and Virginia. So there would be significant differences here, too, between Colorado and obviously California as well. We just pushed out a very dense blog post on it last week examining the differences between Colorado, Virginia, and California's treatment of sensitive data. So if you're interested in it, dig in. Okay, nonprofits. I wanted to get to this. This is, these differences between Colorado and this Indiana bill, and you could say this as well for Virginia, right? These are not all the differences, but these are the big differences in my mind that you want to be aware of. So one is, and CPA is Colorado Privacy Act. That's, it's the acronym there. CPA covers nonprofits. That's not the case in Virginia. It's not the case in Indiana. It's not the case in these other look-alike bills. The right to cure. This is something that I don't think gets enough attention, right? So right now under the CCPA, you have the right to cure violations, right? You have to have a notice, 30 days to right to cure. And that exists in Virginia as well. It's going away in California, right, with the CPRA. Colorado has it, but it's going to sunset 18 months after the bill goes into effect, right? What does it matter then? Well, obviously you'd like to have the ability to cure a violation, right? So it's business friendly, but it also has to do with multi-state investigations, AG multi-state investigations. If you can cure a violation in Colorado or Virginia and you can't cure it in other states, that prohibits AGs from multi-state investigations. So it's a sneaky important provision about whether you can cure violations in one state versus the other state because of that. It really is an enforcement issue in multi-state, not just state. CPA Attorney General rulemaking, we had a question that came in about, do you have an update on Colorado? Yeah, this is it, right? Colorado, the bill, there are no, at least as of this weekend when I checked, there was no CPA amendment bills that were proposed. Having talked to Senator Rodriguez recently, there was nothing on his radar. Not to say something will come out, but at least as of now, it's rulemaking. And, pay attention. There's every reason in the world to pay attention to California rulemaking. It's going to be a huge piece of the puzzle in the next, Q3, Q4. Do not sleep on Colorado. Colorado is going to engage in robust rulemaking in the CPA. And, Weiser, Attorney General Weiser, he's a practical guy. He's not going to do something that's outlandish that hurts business by any stretch of imagination, but, he's also very privacy conscious. And then, the last thing there, too, the distinctions between these bills are, the opt-out signals. There's nothing in Virginia or in Indiana that would require businesses to recognize or controllers to recognize opt-out signals. The other bills that follow this model, I think I mentioned Wisconsin a few times. So Wisconsin, it passed committee yesterday. Assembly Bill 957 did. It has been referred to the Rules Committee, and it was amended before it came out as well. So anyway, there's an amendment there. And then Iowa, it already passed out of committee. The number changed yesterday. If you want the new bill, check out the tracker. We've got it updated. And I'm told, Joe Duvall texted me this morning and said that it's on the House calendar. And Iowa's got some time. April 19th is when Iowa will adjourn. Okay, Florida, the mess that is Florida. Thankfully, this is TK's mess to unpack.
Oh, yeah. So Florida's House Bill 9, authored by Representative McFarland, is actually being heard by the House Judiciary Committee as we speak. So perhaps the status may already be out of date or at least change in a couple of hours. That being said, I also want to note that a number of amendments as well as a strike-all bill from McFarland were filed last night for this hearing today. And so we just want to give you a heads up that depending on what happens here, the provisions, especially regarding applicability and private right of action, could change from what we have on these slides. But looks like California's laws with some modifications have a lot of the same rights and obligations, but there are some differences I'll point out as we go through. As for applicability, you have to satisfy, for now, you have to satisfy at least 2 of 3 thresholds to be considered a controller, which is unlike California where you need to only satisfy one of its thresholds. So again, for now, there's a monetary threshold of exceeding $50 million, which is double California's $25 million threshold. There's a volume threshold. If you annually buy, receive, sell, or share the personal information of 50,000 or more consumers for targeted advertising or a non-exempt purpose. And there's a CCPA-like 50% of revenues threshold. And before we move on, a couple of things I just want to note about that second 50,000 threshold. First, it includes businesses that receive or share personal information, so the scope is broader than requiring that a business actually buy or sell the information. And second, it's not just targeted advertising that could subject you to the law, but also if you're using the information for a purpose that doesn't fall under an exemption. And as for enforcement, it'd be enforced by the Attorney General, and there's also a limited private right of action, and the effective date would be the same as the Colorado Privacy Act, July 1st, 2023.
So TK, just to jump in, our friend Adam Bender from Communications Daily just wrote in on the Q&A saying he's watching the Florida hearing and they're not going to hear HB 9 today. So that means, well, the shelf life on our presentation has extended for like at least a day, right? He asked if it's a bad sign or just a little delay. It's, gosh, Adam, it's anybody's guess, right? Those amendments that were offered last night, and we were looking at those at what, like 8 o'clock, 9 o'clock last night.
Yeah.
They're big. I mean, they are applicability and prior right of action. So anyway, didn't mean to get you off pace there.
No worries. So the exemptions in HB 9 are fairly standard for the most part, but the bill does put a new and pretty significant twist on its GLBA and Hipaa exemptions. So NPI under GLBA is exempt, as is personal information that's not NPI under GLBA, but only so long as it's not used for targeted advertising or sold to third parties. And it's the same deal with Hipaa, or the Hipaa exemption, where non-PHI is excluded from the exemption if it's being used for targeted advertising and sales. Controller obligations, pretty similar to the CCPA and CPRA. Not surprisingly, you gotta have a updated online privacy policy. You need to notify consumers at or before the point of collection. But here, keep in mind that the bill's definition of consumer excludes those acting in a commercial or employment context. And also personal information excludes de-identified, aggregated, and publicly available information. Like the CCPA, controllers must provide a do not sell or share my personal information link. And as a side note, HB 9's definition of sell is basically verbatim to California's. Processing limitations, fairly standard. Must implement and maintain reasonable security procedures and practices, and you have to adopt and implement a retention schedule. And
not to get you completely off kilter, but Adam just emailed and said, actually looks like it will be heard today, HB 9.
Oh my gosh.
Yeah, so it's just back and forth, right? I tell you, it's you know, the carousel doesn't stop, right? All this stuff. So
it's crazy.
In any respect, yeah.
Okay, so consumer rights, we see some common rights for Florida consumers, such as access and portability, correction, and deletion. There's also a right to opt out of sales, again, pretty common, but controllers here are given 48 hours from when they receive the consumer's direction to stop selling or sharing the information. And as previously mentioned, has to have that link. Also, controllers are allowed, but they're not required to accept opt-out requests received through global privacy controls. Yeah, so this is pretty straightforward, but worthy to mention because a lot of bills have a lower opt-in consent requirement age, like 13 or 16, But here, consent would be required to sell or share the personal information of consumers that the controller has actual knowledge is under 18. And this was originally 16, but the House Commerce Committee passed a substitute bill at the beginning of the month that increased it to 18. And complying with CCPA satisfies the parental consent obligation here. For enforcement, it'd be enforced by the Department of Legal Affairs, and the department may grant a 45-day period to cure. It's discretionary. However, there is no right to cure for violating a consumer's right to delete or correct after receiving a verifiable consumer request. And civil penalties may be tripled if the violation involves a consumer who the controller's actual knowledge is 18 or younger, or if the violation is based on one of the three ways a consumer may bring a civil action. That being said, there currently is a private right of action, but it's limited to failing to delete or correct, continuing to sell or share information after the consumer opted out, or selling or sharing information of a consumer under 18 without consent. And here damages would be between $100 to $750 per consumer per incident or actual damages. Court can also grant injunctive or declaratory relief. Again, this information may change depending on what happens. So who knows? Florida also has a Senate bill, SB 1864, but it's seen less movement compared to HB 9, so we're not going to spend too much time here, but there are some notable differences. The applicability of the Senate bill looks more like a hybrid of the CCPA and the Virginia and Colorado laws, with the law applying to businesses that control the processing of the information of 100,000 or more consumers, or those that control or process the information of 25,000 consumers and derive 50% of their global revenue. As for exemptions, neither the Glba nor Hipaa exemptions have that targeted advertising and sales exclusion. Opt-in consent, it applies to minors who are 16 and under, but it also adds opt-in consent for sensitive personal information. And there's no private right of action.
That's Florida, huh? That's Florida.
In a nutshell.
In a nutshell, yeah. A question came in, I think it's a really good one. Talking about HB 9, McFarland's bill, and the question was, it's got broad exemptions. Do you think it's targeted to data brokers? And I, not to be flippant, I think the answer is, ask me tomorrow, maybe, right? Because it's a great question, because this is part of the amendments that were offered, right? Is like they're tinkering with the applicability section, right? And they're also tinkering with the prior right of action section, right? And I think there's like almost an identity crisis in the bill over these topics, right? So it's a really astute question to ask. I just think it's like we just don't know yet. And it could be at the end of the day where HB 9, that is, which is the bill with movement, it's so tinkered with that it has onerous provisions like a limited prior right of action, but it just doesn't apply broadly. So it's a big to be determined. Obviously, this is a snapshot right now that we're looking at, but great question. Wanted to get to it. Moving the map then to the great state of Ohio. Again, give you the introductory slide here so you guys can go away with a basic understanding of the bill. Significant here, there was a number of hearings over the summer on this bill in the Government Oversight Committee. It did pass out of the Government Oversight Committee on February 9th, and then it was listed last week as informally passed. TK actually flagged it, and a few of us were trying to figure out what that meant, and it just meant it was basically delayed. And then last night we were checking, and it's been re-referred to the Rules and Reference Committee, right? So anyway, not a big update on movement there, but there is some movement there. One of the bill sponsors, Carfagna, is actually leaving the legislature, so we'll see how that impacts anything. On the applicability, the actual substance of it, note that its annual gross revenue in Ohio exceeds $25 million. I know that we've had a million times the question asked with respect to the CCPA, hey, that $25 million threshold, is that California or is that global, right? Well, here it's Ohio, right? So it is kind of notable. I can't say that I've ever seen that in a different bill. Maybe I have and I missed it, but it does feel unique to me there. With respect to notable provisions, and this will be the last slide on Ohio, it's got this NIST privacy framework that has been looked at by people on both sides of this debate, and there's a lot of context out there about whether it's good or bad. I don't know. I'll leave that to your discretion to decide. It's there, though, and the concept is if you comply with the NIST privacy framework that you would have an affirmative defense, right? AG enforcement, but an affirmative defense. The usual things, it's got data processing agreements, privacy policy disclosures. These are like the belt and suspenders of privacy law right now. But no opt-out of profiling, that concept's not in there. It doesn't require recognizing opt-out signals. No AG rulemaking, no sensitive data category, right? Now listen, in the defense of the bill, not that I feel like I have to defend it, but what the bill sponsors have said in the committee hearings is they want to create a floor, right? They want to create a floor that can be built upon, and they think that that's the right approach. So, for what it's worth. Okay, Alaska, and we are back to TK.
Yeah, so there are two other bills in Alaska aside from HB 159 that I want to point out. But, those are Senate Bill 116 and House Bill 222. They've both been referred to committees, but they haven't moved since, so we're just going to focus on HB 159 here. Also, just a fun fact, Dave recently recorded a podcast with Representative Fields, the primary proponent of HB 159, so be sure to check that out if you're interested to hear some firsthand commentary. So the status of the bill is currently in the House Judiciary Committee. It's scheduled to then go to the Finance Committee before heading to the floor for a vote. And Alaska's session is currently scheduled to close, I think, in May, so there's still a healthy chunk of time for this bill to make some moves. Kind of resembles the CCPA before the CPRA amended it, but with some more robust provisions, which I'll get to in a minute. As for applicability, a business needs to satisfy one or both of two thresholds, either the 100,000 volume threshold or the 50% of annual revenues threshold. One thing to note here is that the bill does not apply to businesses that just collect personal information. So if you're merely collecting consumer information but nothing more, you're not buying it or selling it or sharing it, then you wouldn't be subject to the law. For enforcement, an action may be brought by the Attorney General or a consumer because there's a private right of action. There's also no right to cure mentioned in the bill, and the bill does give the Attorney General rulemaking authority, both mandatory and permissible, and same effective date as the CPRA and the VC-DPA, January 1st, but the provisions regarding AG rulemaking authority are set to take effect immediately for obvious reasons. Fairly common exemptions for HB 159. There's an entity and information exemption for Glba and Hipaa. Employee data, de-identified, aggregated, and publicly available information, collection or sales taking wholly outside of Alaska, and CCPA or CCPA-like FCRA exemptions. So for the obligations for a business, it looks a lot like the CCPA, so I won't bore you too much here. But I do want to point out that the collection and use limitations require you to limit collection and sharing to what's reasonably necessary to either provide a requested service or that's reasonably necessary for security or fraud prevention, which it excludes profiting financially from the information while you're trying to prevent fraud. But this next part is pretty interesting, the obligations of a person. It requires a person to notify a business if they receive personal information that the business originally collected, as well as provide their contact information and keep that contact information updated if it changes. And if the person discloses that information, they also must notify the business that originally collected it within 10 days of disclosure and give them the contact information of the recipient of that disclosed information. So here it looks like it's just, it's aiming to, I guess, strengthen the chain of custody of the collected personal information as it passes hands. So consumers have a little more control over their information out there. Consumer rights, nothing too crazy here, but I will point out a few things. Access and portability. A consumer may request you disclose their information that you used within the last 5 years. There's the same 5-year period for the right to delete. And, oh, this is a big part. A business must also direct all persons that receive the information to delete and provide a written statement verifying that it's been deleted. And if that person fails to provide the statement, the business must immediately notify the Attorney General and the consumer. Can't discriminate against the consumer for exercising their rights. As for the opt-out of sales, you have to treat the use of global privacy controls as valid. So it's pretty consumer-friendly, you know, making it easy for consumers to protect themselves rather than having to individually opt out for each website. So yeah. Also want to mention that, like Florida's HB 9, the definition of sale is almost identical to the CCPA in that it includes an exchange of monetary or other valuable consideration. However, at the end there, it also adds in or for another commercial purpose. So Alaska's definition broadens the scope of what constitutes a sale even further than California. So how this bill treats minors is a pretty big deal. Not only does it require opt-in consent for consumers under 18 to disclose, sell, or share their information, it also prohibits the monetization of minors by stating that a business cannot track or profile consumers under 18, which is another substantial and pretty novel provision we've seen from Alaska. As for the treatment of data brokers, it uses a CCPA-like definition, including the exclusion of consumer reporting agencies subject to FCRA. The data broker registration requirement is also like California, where you have to provide contact and other information as well as pay a registration fee. But unlike other laws, this is a pretty big deal here. HB 159 also charges a 3% revenue fee that data brokers must pay to the department. So in California, you have to pay a small fee, but here it's based on the revenue that data brokers are pulling in from buying, selling, and sharing personal information. So that's pretty significant.
that Alaska? That is Alaska.
That's Alaska.
Yeah, you know, just to sort of footnote that, right? So when we did the podcast with Representative Fields, you know, this data broker thing is a big deal.
Yeah.
It has to be. It would be. I haven't seen it before. The 3% revenue fee here. Now, I don't know. I mean, the last committee hearing, you know, Representative Fields said in the committee hearing, you said he'd be surprised if the bill passes this year, right? But certainly one of those bills that they're trying to up the bar on privacy, you know, standards in this country. And, you know, it's no surprise, too. I mean, he said in the podcast that Ashkan Sultani, who's now the executive director of the California Privacy Protection Agency, before he had that position, he had his hands in this bill. Maureen Mahoney from Consumer Reports has been a big influence in this bill, testified multiple times in committee hearings, right? But you see that with this Alaska bill. You see this concept of, you know, elevating, you know, the requirements on businesses, certainly throughout. Just to do a little cleanup before I get on to Connecticut. Just a couple of questions came in. One was, you know, that affirmative defense for NIST privacy framework in Ohio. Have I seen that anywhere else? I have not. I've not seen that in any other bill. Ohio is the only place I've seen it. If I've missed it, but that's the only place I've seen it. There was also a question about going back to Florida and HB 9, McFarland's bill there, about why do you, if you have the entity exemption for GLBA, why is an information exemption also necessary? Yeah, I mean, we see that sometimes where you have both exemptions in there. I suppose that's the, just buttoning it all up. But I think the important part, which was on TK's slide earlier, is that it would exclude targeted advertising and sales, right? So the exemption would stop insofar as, like, yes, if you're doing X, Y, and Z with the data, but if you enter into targeted advertising and sales, we're not going to apply the exemption, which is that's the first bill I've seen that treatment of a GLBA, and extends to Hipaa as well. So that's really worth paying attention to if you're in those states, and if you're, you know, subject to those federal laws. And then there was a good question that came in about, like, when we get to this idea of, like, counting consumers, right, and 100,000, and whether, you know, how do you count those? And basically, I think the question relates to the storage of data, whether that would count, like if it's already on your servers, or does it have to be, like, annually collected? What I'd say to you is where that really comes down to is the definition of process in these state laws. And a number of those laws, and I can't say obviously for all these bills, we haven't done the analysis, but if it includes the word store in the definition of process, then that's where you really need to focus on to determine whether it's, you know, just annual collection, or is it actually stuff that's on your servers. And I believe Colorado is store, and I think that's in Virginia as well. Obviously, you're catching me off the top of my head, but yeah, it's a great question as well. Okay, so a lot of that to try to clean up a couple questions, but let's move to Connecticut. Connecticut's an interesting bill to talk about because it hasn't been introduced yet, right? But it's coming. It's coming as early as this week, if not early next week. There's a placeholder. SB6 has been placed there for now, but, you know, the draft bill has been circulating. There's a work group meeting tomorrow. Senator Maroney set up a work group over the summer, various stakeholders to, you know, work through a number of issues. There's another meeting tomorrow morning on the bill. So I anticipate that we'll see a draft bill get introduced in the short term. I think that's the plan. What does it look like? It's the CPA, it's the Colorado-Virginia model, and it's got touches of CPA, and I can tease those out in the next slide. The applicability, it looks very much like Virginia. I had the 100,000 there with an asterisk because that might move to 65,000 or something around those lines. The thought process there is, hey, you know, Colorado's got 5.75 million people. Connecticut's got 3.5 million, so doesn't the 100,000 have to adjust if Connecticut has 62% of the population of Colorado? Shouldn't the 100,000 adjust with that? An interesting concept there, but we'll see. I mean, we'll see what the final bill looks like. We did a podcast with Senator Maroney as well, worth mentioning that if you're kind of interested in his take on it. You know, and again, this right to cure, which I went on about before, obviously, but it would sunset, at least as the current draft that I've seen. You know, what gets filed, we'll wait and see. Notable provisions here are, you know, Will it recognize the opt-out signals? To be determined. I think it's going to be in there for sure. I think the question is going to be whether it's mandatory or discretionary. I think that's what it's going to come down to. And it will have the same construct of processing sensitive data, those types of things. Similar exemptions as you see in CPA and VCDPA. And we'll wait until the final bill comes out before we talk about those. And then this CPRA I talked about in the last slide about like this idea of the CPRA aspects. That's really like the treatment of children from the slides TK was talking about earlier, and whether that's going to be like a under 16 threshold or under 18 threshold remains to be seen. But there are going to be steps in place to try to go beyond COPPA and provide those protections. Okay, and we'll tell you more about Connecticut once it comes out, but obviously just teasing it for now. On to New York and back to TK.
Yeah, so New York has a bunch of bills, but we're just going to focus today on the New York Privacy Act because that's where we've seen some movement. And just to give you a heads up, these bills have been around for a while, or, well, Senate Bill 6701 and Assembly Bill 680, so we're not going to spend too much time on them here. As for the status, the Senate bill has passed the Consumer Protection Committee and is now with the Internet and Technology Committee. The Assembly bill is still with Consumer Protection. Looks like not really applicable because the provisions here don't exactly align with anything out there, which we'll see as we go over some of the provisions. So the New York Privacy Act would apply if you satisfy one or more of the following thresholds, either a $25 million monetary threshold, a 100,000 volume threshold, and this third one puts kind of a new spin on things, an additional volume threshold where you control or process the data of 500,000 persons nationwide and 10,000 New York customers. Or you derive 50% of revenue from sales and control or process the data of 25,000 or more New York consumers. So enforcement by the Attorney General, and there's a private right of action if you violate a consumer's opt-in consent right to automated decision-making, or fail to respond to a consumer request. So notable provisions under the notice requirements, the bills explicitly state that privacy policies must be written at an 8th grade reading level or below, and each version for the past 6 years must be easily accessible to consumers. Opt-in consent is required here to process data that doesn't fall under an exception. And here, controllers are required to recognize those opt-out signals. And in the event of a merger, acquisition, or bankruptcy, where another entity assumes control or ownership of the majority of the controller's assets, any consumer consent that's previously been provided to the controller shall be deemed withdrawn. That's pretty interesting.
Yeah, and that eighth, while you're turning your page, that 8th grade level for privacy just gives me makes my mind, boggles my mind. So.
Yeah, so moving right along, controllers, they have to conduct a data protection assessment if your processing presents a heightened risk of harm to the consumers. And you also have to conduct a risk assessment at least once a year of all current data processing. Agreements with processors are required, and a controller can't agree to indemnify, defend, or hold a processor harmless from liability. And similar to California, data brokers must annually register with the Attorney General, provide contact and other information, and pay a $100 registration fee.
So on to Oklahoma. It's interesting. If you tune in, we did this webinar when I was DK. I did it with Sarah Rippey last year, who was in your position last year at the IEP.
Yep.
And, we got to Oklahoma, and I said, who thought we'd be talking about Oklahoma? And I got a lot of grief for that. But, we're talking about Oklahoma again, and the reason is it's Representative Colin Walkie. It really is. And, Representative Walkie is very passionate about this issue. He's very educated. He's got now 2 IAPP credentials. I believe he's up to 2 right now. And, it's a passion project for him right now. It really is. Kind of giving the oversight, I've got 2969 up here, right? Just give you like an understanding of what's going on based on my understanding of that and interacting with the lawmakers there. 1602 is the bill last year we talked about that passed the House, waiting for a hearing in the Senate. That bill is still live, waiting for a hearing in the Senate. Okay. Representative Walkie introduces 2968 and 2969 this year, right? Understanding, talking with him, is 2969 is the bill, that there was a technical glitch with 2968, so 2969 is the one that is really the active bill. And to that end, that's the bill that passed the Technology Committee, okay? The current status on it is 2969, it's waiting a floor hearing in the House. 1602, the one that passed last year, is still waiting for a hearing in the Senate. It's been waiting for about a year, I should say. Moral of the story here is a couple things. One, applicability, $15 million, right? That was, and I should have mentioned, 2969, as originally introduced, different bill from what it is now. Last week at the committee process, Representative Walkie does a strike all, and he puts in basically 1602 gets put in for 2969, so both bills are identical, with the exception of 2969 has a $15 million threshold. 1602 has the existing $10 million threshold, right? Whether those would match up eventually, I don't know, but that's basically the lay of land, right? You've got 2 similar bills that are there, and it looks like CCPA plus consent. It has exemptions, and you guys can take a look at this one. It looks like the exemptions we've been looking at before. I really wanted to get to this slide because this is why Oklahoma matters, right? This is the bill in a nutshell. This is deliberate. This is, notice and consent to process sensitive data, okay? And I've seen questions on here about what would constitute personal data, all this other stuff. Yeah, this is a broad definition of personal data. It includes IP addresses. It's the CCPA definition. They are deliberately trying to set a high bar. When a bill passed out of the committee, Representative Walkie was on Twitter saying this would be the first consent-based privacy statute. Deliberate, completely deliberate. This is not unintentional. And this really gets into, in my mind, when I've talked with all these lawmakers on the podcast, and, what's your approach? There's a number of different approaches. Some people want to create a floor, like Ohio. Some people want to set a new standard, and that's what they're trying to do in Oklahoma, right? And listen, whatever your approach is, wherever you sit, that's fine. People have different opinions on all these types of things, but that's what you're seeing happen, right? And I should say, too, these lawmakers care, right? To a person, these lawmakers care about this issue. They just may take different approaches to these issues about setting a high bar, setting a floor, all those types of things. They're trying to set a new high bar in Oklahoma. Okay, the rights, just to kind of give you a tease here, I think the issue here, there's this opt-out sale, opt-in the sale. It's consent-based, right? So, even though you have to get consent to collect data, you still have the right to opt out of the sale of that data. You still have these rights around your data. And, you have the online privacy policy, all those types of things. Really, Oklahoma, in my mind, comes down to consent. That's really the issue. Okay, let's move over to Massachusetts and TK again.
Yeah, so in Massachusetts, the Committee on Advanced Information Technology, the Internet, and Cybersecurity recently redrafted, with bipartisan support, the Massachusetts Information Privacy Act into the Massachusetts Information Privacy and Security Act, also known as MIPSA. The Senate bill number is 2687. There will be a new House bill number, but it looks like they still have yet to process the redraft, so stay tuned there. But the Senate bill is currently in committee, and MIPSA kind of looks like a hybrid of the California, Virginia, and Colorado laws, but it also specifically applies to data brokers. As for applicability, MIPSA applies to controllers and processors that conduct business in Massachusetts offer goods or services targeted to the residents, or monitor the behavior of the residents. However, the provisions regarding controller obligations and the rights afforded to consumers, they only apply if a business meets at least one additional threshold that we have listed here, either a $25 million monetary threshold, a 100,000 volume threshold, or if you qualify as a data broker, which is defined as a controller that knowingly collects and sells either the sensitive information of at least 10,000 residents or the personal information of at least 10,000 residents if there's no direct consumer relationship. It'd be enforced by the Attorney General. There's a modified right to cure, and also a private right of action for data breaches, which I'll go over in a minute. And the effective date would be 18 months after enactment, but the rulemaking authority would take effect immediately, and there's also a 2-year delay for nonprofits and higher education institutions to comply. Here are some of the exemptions for MIPSA. This is certainly not an exhaustive list, but they're all fairly standard, so in the interest of time, I won't get into too much detail, but just note that the GLBA and Hipaa exemptions apply only to information, not entities, and the exemption for residents acting in a commercial or employment context does not apply to their right to opt out of sales. We also wanted to point out some of the more significant definitions in MIPSA. For example, the bill's definition of biometric information is very similar to the VCDPA's definition. So it looks like MIPSA may also exclude data from facial recognition technology like Virginia has, but well, we'll have to see. Personal information excludes de-identified and publicly available information, pretty common. There's also a California and Colorado-like definition of sale, the part where it says for monetary or other valuable consideration. But MIPSA also adds in at the end there, or for the purposes of targeted advertising, which will be important to keep in mind when considering a consumer's right to opt out of sales here in a minute. And targeted advertising excludes advertising to a resident in response to their request for information and feedback, if it's based on the context of their current search query, or processing solely for measuring or reporting ad performance. So controller obligations, again, this is, a non-exhaustive list, but be sure to have, a clear, easy to understand privacy notice, as well as conspicuous links on your homepage. But here, it's not just for opting out of sales. They also require a link to allow consumers to limit the use and disclosure of their sensitive information. So that's good to note. As for the processing limitations, to limit the amount of personal information collected and retained, MIPSA it looks like they're taking a page from the GDPR by requiring that collection and use have a specified purpose, and that there needs to be a lawful basis for processing, such as consent or performance of a contract, or complying with a legal obligation, or an entity's legitimate interests, which must align with reasonable expectations. There's also an opt-in default requirement age. So if you obtain consent, you must obtain consent prior to selling the personal information of a resident who's 16 or younger. Pretty common consumer rights: access and portability, the right to delete, standard exceptions, correction. There's also a right to opt out of sales and targeted advertising, and you must wait 12 months at least before asking the resident to renounce their opt-out decision. But keep in mind that minor residents under 16 have an opt-in right here, not opt-out. Residents may also limit the use and disclosure of their sensitive information, like I mentioned earlier, and this is limiting it to what is necessary or reasonably expected by an average individual under the circumstances. So essentially, Massachusetts consumers, to an extent, can now or in the near future potentially restrict how controllers use their sensitive information. And you also can't discriminate. So standard controller-processor relationship provisions. Treatment of data brokers is pretty similar to California. Risk assessments, they're required for high-risk processing activities, like processing sensitive information, selling personal information, and making evaluations based on automated processing. And here the bill also empowers the AGO to obtain these assessments, and and the reciprocity and interoperability provision enables entities to comply with the law if they're compliant with an equally or more protective privacy law. So MISA would be enforced by the Attorney General's office, like I said earlier, but we just want to kind of tease out some of the details here. First, there's a modified 30-day right to cure for unintentional non-repeat violations that will sunset in 2 years after the effective date if you're an entity generating over $1 billion in annual revenue and control the personal information of 100,000 or more residents. So penalties of up to $7,500 per violation, depending on the size, scope, and conduct of the entity, and data brokers, if you fail to register, penalties of up to $500 a day. And in addition to enforcement authority, NHTSA also empowers the AG's office with investigatory and rulemaking authority. And there's also that limited private right of action for security breaches, damages up to $500 per individual per incident, and it's also worth noting that there is a safe harbor here if you meet industry best security protocols such as the NIST standard, but the safe harbor won't apply if the failure to implement reasonable controls is a result of gross negligence.
So we are horribly over time. I'm cognizant of that, but I see we still have hundreds and hundreds of people on. So let me try to give you Nebraska and then the California, Virginia in like 2 minutes, and then, but obviously drop off if you have to. But since so many of you are on, listen, Nebraska is, we've grouped 3 states together. Nebraska, Oklahoma has a bill as well, and then DC. These are the Uniform Law Commission bills, right? So Uniform Law Commission puts out a model bill. Look, we just got to the chase. It hasn't been, it's not bad. It has not been well received by privacy advocates. There was a critique that was done by Professor Soloff over the weekend. It's on teachprivacy.com if you want to take a look at it. That gives you the nuts and bolts of this, right? Here's the applicability. I think the only thing to know is, like, with Nebraska, it's the only one that we've seen movement on. There's a hearing scheduled for the February 28th next week. We'll see if something happens here. The other 2 bills, we don't have movement yet, okay? This is the rub, right? This is the rub. It's compatible data practice. The idea is, you can operate within certain boxes about compatible data practices. If you go outside that, then consent comes into play, either you need to provide people with the opt-out right if it's non-sensitive data, reasonable opportunity to withhold consent, or you've got to get consent if it's sensitive data. But again, the controller is the one really, based on a factor analysis, determining what is this compatible data practice. And Professor Sullivan, in his critique, he said, quote, "The law is essentially allowing the fox to guard the hen house and telling the fox to only eat chickens when compatible with its appetite," right? Was this sort of approach. Listen, it is what it is. You take whatever approach you want, but this bill, it really comes down to compatible data practices here is really the rub. There is limited rights under the bill. There's no right to deletion or portability, and it actually authorizes targeted advertising, which is contrary to everything we've been saying for the past hour. And like I said, District of Columbia and Oklahoma also have bills that follow this model to date. The CCPA amendments, I'm going to buzz through this one. Listen, go on our LinkedIn page. You can find it there. 5 bills met the deadline to get out of the House of Origin, and these are the 4 topics: a new exemption to the right to deletion, repeal the Consumer Privacy Fund, modify the definition of nonprofit organization, and add in political organizations as well, and then change treatment of sensitive data. March 12th, we're drawing close. If you want to read about these bills, go on my LinkedIn page. I put out something on Saturday, gave you the biggest update on that. Finally, then, the California update. Listen, the regs are delayed. Probably heard. Already, if you're on this webinar, you probably heard. Q3, Q4. The big news over the weekend, it happened on Friday and then was talked about on the weekend, is 2 bills were introduced to extend the B2B and employee exemptions. I know there's been a lot of questions on this here. So do I know if these bills have any shot? I don't know if these bills have any shot. I don't think anybody knows if these bills have any shot right now. But, they're there. We'll see what happens as the California legislature closes. Okay. Listen, if you've attended this far, I always call this the shameless plug piece of the conversation. We've got a blog. We track all of these things. We push out those weekly alerts for the status of state privacy laws. If you're not getting those weekly alerts, use the QR code and subscribe to the blog. We really try to be respectful and not push out everything, only push out important things. And then, there were some questions as well about interoperability of various provisions. We've been doing a 10-part series right now on how the CPA, CPA, and DCDPA treat different aspects. So if you're interested in things like sensitive data, if you're interested in things like publicly available information, all these really complex topics, track us, and you can do that through the blog. Mentioned data privacy unlocked a few times. If you want to hear me talk more, probably at this point you want to hear me talk less, but at this point, you can track it. We have, as TK mentioned, I think she mentioned, we have one more coming out in the short term with the Massachusetts bill sponsors and the House side. That's it. That's our big finish. The appendices are here that go into a number of the questions that you guys asked. Appreciate you hanging on. Really apologize for going over the 7 minutes. We did our best, but hopefully the additional time is well worth your time. We will see you on the next webinar. Thank you.